Earlier this week, a judge in Steuben County, having adjudicated a Republican-sponsored lawsuit to overturn the lines established by the state legislature, issued a proposed set of district lines for congressional seats and state Senate seats in the state of New York, prepared by his assigned special master. In reviewing those district lines and their impact on Westchester County and across the state, it is my judgment that these lines are unconstitutional and fatally flawed. Assuming that the state judge imposes these lines regardless, a federal lawsuit should be filed to stop their implementation and rather to require the state legislature to draft new district lines for the House and state Senate districts, subject to judicial review, rather than assigning the constitutional authority that is granted to a duly elected legislative body to an unelected master. These proposed district lines are unconstitutional because they unfairly dilute the power of minority voters in both elected bodies, specifically changing district lines unnecessarily and pitting incumbent minority elected officials into the same districts. The New York State Constitution additionally requires communities of interest and cores of existing districts to remain intact to the greatest extent possible. This proposed set of plans strips minority voters of elected officials who have served and gained seniority, essential to exerting power over public policy in these two chambers. Federal and state legislative bodies operate on a seniority system where long-term members chair committees and exert prerogatives that benefit their residents. When New York lines are structured simply to shuffle the deck of elected officials, those states that do not do that, Texas, Florida, and others, New York will be represented by those with less seniority and less influence. As an example, this plan needlessly places two powerful House members, Yvette Clarke and Hakeem Jeffries, into the same district. The loss of either one, with their accumulated influence in the House of Representatives, is a loss for the African American populations they represent. The desire to have a blind eye establish district lines without a keen understanding of those specifics makes this a flawed plan. There are other such examples which reinforce the belief that minority power is harmed by this plan. The Voting Rights Act has been under siege by those who seek to reduce the minority voices of the community. The traditional gerrymandering for political advantage practiced by both parties over past plans cannot now be claimed by one party as a weapon used only by the other. I endured a gerrymandered state Senate race for a seat 10 years ago. Although I won the race, the lines were clearly drawn in an attempt to take away what was then a seat held by a prior Democratic incumbent and provide it to the Republicans. If we seek more fair lines, it is wholly appropriate for the court to direct the state legislature to prepare new lines, subject to their review, within a short period of time that would still allow for the August primary date which the court has established. The future of our state and nation is at stake with these lines. We cannot accept what I perceive to be a fatally flawed plan with a shrug and a sigh. We will have 10 full years of public policy to lament and regret what we do not fight for right now.